Hi everyone, this is the video lecture on Malpractice Ethics. This builds on the topic from last week where we talked about the legal aspects of ethics and what we are held responsible for once we join this profession. And so this kind of just talks about what happens if a complaint or a violation occurs and kind of what does it really mean to be engaged in malpractice. So we'll define it, we'll kind of talk about some of the things that have to be in place, and then we'll talk about different types of malpractice, kind of the area of what happens when you are impaired or appear as impaired, and then ways to hopefully prevent malpractice. It's an unfortunate thing that we have to talk about this in social work. I would like to think that we all will hold our duty to protect clients, but I think this is a really good example of kind of that reformed perspective on social work, is that we live in a fallen and broken world, and although we are agents of restoration and redemption, we are susceptible to being part of the fall as well, and there is going to be brokenness and injury that occurs through our actions or inaction. So it's an unfortunate thing, but it's very important just because we need to be aware of kind of our implications behind this and how to protect ourselves and our clients. So if we look at the definition of malpractice, I'm going to first preface that I'm very aware that this reference is from 1994, which is probably before many of you were even born. But because it's a definition, it's acceptable to still use a dated source like this. So I am aware that it's 1994. It's like jumping out of the screen on me. But it's still an applicable source because it's defining what malpractice is. So when we refer to malpractice, we're talking about a form of negligence that occurs when the practitioner acts in a manner that is not consistent with the profession's standard of care. So essentially, they act in a way that goes against the ordinary, reasonable, and prudent way that a professional would act under similar or same circumstances. So it deviates from the norm in a way that harms somebody else. So if that occurs, a person or a group may file a lawsuit in civil court because the injury or suffering that resulted from the negligence or resulting from the wrongful actions or inaction of the professional person. And usually this is in the form of monetary compensation to kind of address the injuries or suffering that the client or the family have experienced because of the act of malpractice. So it does not necessarily have to be the client who is seeking the lawsuit. A family member can, on behalf of a client, if they're not able to advocate for themselves, or if the client has passed and they're seeking monetary damages in light of the client's death. So when malpractice occurs, there's evidence that there's 4 different elements in place. And so one of the first things that has to be in place is that at the time of the alleged malpractice, a legal duty existed between the practitioner and the client. So if we want to attach an example to these 4 things, this step would be that the practitioner and the client agreed, usually in informed consent, that information disclosed during their relationship would be kept confidential. So that was an agreement that both parties were under and understood that would happen. The second piece that would be in place is that the practitioner was derelict or negligent in that specific duty that they agreed to, either through an action, so that would be like the act of commission, or an act of omission. So, for example, the confidential information was divulged to a public welfare agency without the client's permission. So the practitioner shared something that he had agreed not to. The third element is that because of that action, the client suffered some injury or harm. So in this example, because the information was shared with the public welfare agency, the client lost his benefit. So let's say it's food stamps. So the harm or injury was, and this is the fourth one, the harm or injury was directly and proximately caused by the professional's dereliction of duty. That's a really fancy way to say harm or injury occurred because of the practitioner's action or inaction. So if this example continues, it shows the client suffered financial injury because the social worker's unauthorized disclosure of confidential information. So There are some pieces that are looked at in this. As I get into the next slide, actually, you can see that there's 4 different ways that a client or a family member could file a report. And not all of these come with like a criminal implications, like you won't have a criminal record if some of these things happen. So the first one would be a report is made towards the state licensing board. And so an investigation happens. It's determined whether or not there's a violation of the profession's code, and you would get your license either suspended, put on probation, or not change at all if they find that the complaint was not substantiated. Similarly, it could be reported to the NSAW if the social worker is a member. That kind of goes hand in hand with the state licensing board. So if a report is made to the NSAW, they found that the provider was in fact engaging in malpractice, they would also report it to the licensing board. So those kind of go hand in hand. It also could get reported to a civil court of law and a criminal court of law. Those then have a little bit more criminal record implications if something does occur. So as in criminal trials, social workers in civil suits are presumed blameless or innocent until proved otherwise. This differs a little bit from the licensing board cases that get opened, is if there is what they call predespondence of the evidence, which means just like it's pretty likely that it happened. There's like at least 50% or more chance that it did occur. They're going to open up a case and pursue it in the effort to protect the client. It doesn't necessarily mean that you will get charged with malpractice and your license will get revoked, but it does allow an investigation to occur. And what will sometimes happen in the predespondence of the evidence is you get your license suspended while if there's enough evidence to believe that there's actually something that probably happened, the license will get suspended while the investigation is occurring. So there's 3 different types of malpractice: malfeasance, misfeasance, and nonfeasance. Again, very fancy legal words to describe pretty, I would say, basic concepts. So I'm going to kind of break down all 3 of them because they're very similar to the acts of omission and commission that we talked about last time. It just kind of is attaching more legal terms to it. So when we're looking at malfeasance, this is when the practitioner consciously engages in a practice known to be harmful. So it involves an intent to harm or malice and may constitute criminal behavior because they are making, having awareness that the choice they're making could harm the client. Whether that's their intent or not, it is being something that's kind of proactive. So this would fall under those acts of commission where someone was intentionally doing something. So examples of this is kind of at a macro level. If you're embezzling client or donor funds to work to your advantage, again, the intent might not be to hurt the client or hurt the agency to benefit yourself. Regardless, it's still a form of malpractice. Thinking more like on a micro and meso level, if you are providing services outside of your scope of practice. So let's say you have never been trained in EMDR, which is a form of therapy, eye movement rapid, desensitization. So again, I can't even pronounce it because I'm not qualified to provide it. It's like a very involved training process. You can only implement that type of therapy if you've been properly trained. So if I were to tell a client like, yeah, I can do EMDR with you, I would be engaged in malpractice because I'm not certified and don't know what the heck I'm doing. Sexual harassment and sexual taking advantage of a client, that's often one that comes to mind when you hear of malpractice. So whether a client and a practitioner engage in a consensual relationship or a non-consensual relationship, obviously having sex with your client is a no-go, and that is a form of malpractice. It's an act of commission because they're actively doing something. I think my most bizarre experience with a type of malfeasance was when so in the clinic I worked in, we were able to do, and there was some expectation actually that our case managers would spend 50% of their time in the community doing home visits. So you had to trust that your case managers were doing what they were saying they were doing when they're in the community. And so we had a a staff who would document that she was at clients' visit. She'd have her times in. This is what she did. Well, things started to unravel when clients would call in and say, hey, we haven't seen our case manager in X amount of days. We'd look at the documentation and it would be in her notes that she saw them. Well, we started cross-referencing her schedule, the time she said she was going to be there. And there was a lot of errors, like where she wouldn't be able to physically drive from one place to another in the time that she said. Sometimes there would be overlaps of times. Turns out she was going home and just hanging out at her house and then just typing notes as if she was doing things. And needless to say, she got fired. She was also a person of color, so she countersued and said that we were discriminating based on her race. And it turned into this very nasty legal battle, but we had enough evidence to show that there was inconsistencies with what she was saying. I ended up leaving the agency before everything got resolved, but it was very interesting. But that would fall on if she got convicted. That's not really the right word because it wasn't going to civil court. It was just with internal. That we had enough evidence to show that she was acting out in a way that would qualify as malfeasance. Misfeasance is more of a marriage between an act of omission and an act of commission, where you inadvertently did something that violated the code of ethics. So one of the main examples is like accidentally leaking confidential information or leaving a paper out or taking your work home and your husband happens to see it and he's like, oh, hey, I went to high school with her. Like, ooh, that's a breach of confidentiality. So forgetting to do something, so kind of having that negligence or carelessness, still an act of a commission because you're doing something, but it's not necessarily with malice or intent to harm. If you're working, and this is not necessarily a social worker one because we don't necessarily administer medications, but if you happen to like tell a psych hospital that your client was on X amount of Zoloft or something, and they took your word at it, well, that's not within your scope of practice either. You're inadvertently doing something that harmed the client. Forgetting to get a signature for services. So again, this isn't coming with malintent, but it results in harm for the client. And nonfeasance is basically an act of omission where you didn't do something and then it resulted in harm. So like if you had a client who was suicidal and you just forgot to follow up with them, and then something ended up happening, they completed suicide, that's an act of nonfeasance. Not providing adequate care services upon termination. So that could actually result back to the case study we talked about. Excuse me, I have a cold. Last time where the client went to Texas. So if we just would have let him go without attempting any sort of aftercare follow-up, that could have been looked at as nonfeasance, those types of things. So it's important just to be aware of, like, again, that sometimes inaction can still be considered malpractice even if we're not intentionally doing something. So sometimes ethics complaints and lawsuits arise out of practitioner impairment. So that's just saying that something is going on in the practitioner or provider's life that's causing them to not be able to see things clearly. So that could be just stress at home, stress at jobs, substance use, basically anything resulting to mental illness or addiction that's causing them not to be able to think clearly. That kind of does fall under that practitioner impairment and leaves the practitioner and the clients very vulnerable to unintentional malpractice. So if we're looking at ways to prevent malpractice lawsuits or unethical types of behaviors, you just need to educate yourself on ethics. The Code of Ethics gets updated quite a bit. Like recently, they added social media policies. So that's a change since I've graduated. So you really need to know that what you're legally being held to. And so I consult the Code of Ethics all the time when there was legal dilemmas because it does kind of guide you. Know and recognize the signs of impairment. So it kind of goes to that self-awareness piece. The NSAW provides ethics supervision if needed. Often agencies will as well, but if you're in private practice, utilizing the NSAW does really help. Referring impaired peers to EAP, which is like employee assistance program. So that's counseling provided by an agency, recognizing the signs and knowing when to refer peers for help